The administration's position was pre-Hamdan that they could circumvent also Common Article 3. Now, when confronted on it, they say, what we ended up doing was in fact consistent with Common Article 3, but that was as a matter of grace, not as a matter of obligation.
And the court found them wrong on that.
That's for sure.
Quite correctly.
We need to let Sean.
Yeah,
Sean?
Sean.
Go for
No,
it.
this is great.
Give him a mic so he can,
I'm not sure this is, I'm not,
if it's not on, touch the bottom, see if there's a switch on the bottom.
Well, I think one of the more useful lines of thought that we've taken at the conference so far is to burrow down and to find out what was behind some of these policies and decisions. And it seems clear that unitary executive theory had a role, but also, as was pointed out on a few earlier panels, that we made the determination quite early on that we would need to interrogate. And that the conventions, the Geneva Conventions, and some human rights obligations presented an obstacle. But it wasn't this, I think, that we wanted to interrogate, but if you look closely, particularly at some of the early iterations of the 2002 policy memoranda, the torture papers, as they're sometimes called collectively, that the goal was to interrogate with impunity. This wasn't this sort of ticking time bomb scenario where we were faced with this terrible choice, and we were willing to accept the consequences of violating legal norms in situations that were extreme. That a critical part of the 2002 memoranda is to insulate the people that are making these decisions from criminal responsibility. Now, are they afraid of the International Criminal Court? I'm sorry to say that no, they're not. That these arguments about this poor soldier who gets hauled off to The Hague, and so such that we get the American Service Members Protection Act that auzes the president to invade The Hague to save any service members that are tried before the ICC. I'm sorry, but the authors of these memoranda weren't afraid of the ICC. They weren't afraid of the ICRC. They weren't afraid of the European Court of Human Rights. They were afraid of this. They were afraid of the War Crimes Act of 1996. They're afraid of a motivated assistant United States attorney that reads 18 U.S.C. 2441 and says, wait a second, grave breaches of the Geneva Conventions are federal criminal crimes. What's more, after 1996, we amend the War Crimes Act to include Common Article 3. After watching the prosecutions in Yugoslavia from the International Criminal Tribunal there, we conclude, wait a second, we don't have a mechanism by which to prosecute offenses that arise in non-international armed conflicts, so we incorporate offenses of Common Article 3 into our federal criminal code as well. And the driving force, the foundation of the arguments that are made in these torture memos, it's clear, are an effort to engineer their way around the War Crimes Act of 1996. Now, and I'll just end here so we can move on, but isn't that ironic? I mean, for a long time, we're being called to task because we haven't fully implemented our obligations under the Geneva Conventions. Up until 1996, the United States had not included a mechanism in our domestic criminal enforcement regime whereby we could prosecute grave breaches. And the Geneva Conventions, each of the 4 conventions, establishes the duty for every party to have such a mechanism. Moreover, to do so on the basis of universal jurisdiction. Now, the War Crimes Act of 1996 does not go quite that far. It is not a source of universal jurisdiction. Either the offender or the victim must be American national in order to prosecute there. But, okay, so we finally make good. We come through and we have this mechanism, but then it's turned around and it becomes the driving force behind a deliberate effort to marginalize those same conventions. It's a sad irony that implementation becomes the demise of the conventions in this country.
Just to comment on that, Bob, and just to follow up what Sean said in terms of the 1997 War Crimes Act. When the Hamdan decision came down, everybody assumed that the key to the decision was not Article 31C, but 31D. In other words, you have to be convicted before a constituted and recognized court. That's really not what bothered the administration. They thought the Military Commissions Act would take care of that. What they were truly concerned about was the fact that the 1997 War Crimes Act said that you can be prosecuted in federal court for a violation of Article 31C violations. And so one of the first things they wanted done by Congress, a very compliant Congress, in the Military Commissions Act was to make 31C go away. And so they came up with something called the grave breaches of Common Article 3. And all the international lawyers around the world looked at each other and said, what the heck are grave breaches of Common Article 3? And Congress said, well, here's what they are. They're 1, 2, they're 3. Guess what? Article 3(1)(c) didn't make the cut. It was not a grave breach of Common Article 3, and so you could no longer be prosecuted under the Military Commissions Act for violations of Article 3(1)(c) by legislative fiat. So that's what they were truly concerned about, just to follow up on what Sean has indicated.
Joe, did you want to comment?
Well, no, and just so that, just to tie the bow on it, the idea was, because they believed, in good faith but mistakenly, I agree with Bob that it was in good faith, but it's apparent now that it was mistaken, that they believed they needed the flexibility to employ techniques that by any legitimate reading, by any rational reading, were a violation of that article. And so therefore, you needed to find the article away. And so you start with the idea that, look, give us the power to do that which we need to people in DOD custody, and a separate power to do that which we think we need to people in CIA custody. Because we can't leave, here's the fear. The fear is that you're going to leave some intelligence on the table. The guy's going to have some tidbit that you're just not going to get unless you can do whatever it is you want to do with them. And you don't want any court telling you it's wrong, and you don't want anybody hauling your interrogators in front of a judge. So make the law such that I can do that. That was the objective. And they did it. That's what they tried to achieve. And we saw that.